Laws, Chapter 11. Laws concerning leadership and politics.
In my opinion, Cleinias, the ancient lawmakers were too lenient and made laws without sufficient observation or consideration of human affairs.
What do you mean?
What I mean, my friend, is that they were afraid of the testator's criticism, so they passed a law allowing a person to dispose of their property as they pleased. But you and I, if I am not mistaken, will have something better to say to our departing citizens.
What is that?
My friends, we will tell them that it is difficult for them, as mortal beings, to truly know what belongs to them. It is also difficult, as the Delphic oracle says, to truly know oneself at this moment. As the legislator, I consider you and your possessions not as belonging solely to yourselves, but as belonging to your entire family, both past and future. Furthermore, I consider both family and possessions as belonging to the state. Therefore, if someone approaches you with flattery when you are suffering from illness or old age and persuades you to dispose of your property in a way that is not in the best interest of all, I will not allow it if I can help it. I will legislate with the well-being of the whole in mind, considering what is best for both the state and the family. I will value the feelings of an individual less in comparison. I hope that you will depart peacefully and kindly towards us, as you are going the way of all mankind. We will impartially take care of all your concerns, not neglecting any of them if we can help it. Let this be our introduction and comfort to the living and dying, Cleinias. The law shall be as follows. If a person makes a will and is the father of a family, they shall first designate any one of their sons as their heir, whom they deem suitable. If they give any of their children to be adopted by another citizen, the adoption shall be recorded. If they have a remaining son who has not been adopted and is expected to be sent to a colony according to the law, the father may give him as much of the rest of his property as he pleases, except for the paternal lot and its fixtures. If there are other sons, the father may distribute among them any surplus property beyond the lot in whatever portions he pleases. If one of the sons already has their own house, the father shall not give them money. Similarly, if a daughter is already betrothed, the father shall not give her money. However, if she is not betrothed, he may give her money. If any of the children are found to have acquired another lot of land in the country after the will has been made, they shall leave that lot to the designated heir of the person who made the will. If the testator has no sons but only daughters, they may choose the husband for any one of their daughters and designate him as their son and heir. If a man has lost his son when the son was still a child and not yet considered an adult, whether the son was his biological child or an adopted child, the testator shall mention this circumstance in the will and designate someone else as their second son in hopes of better fortune. If the testator has no children at all, they may select and give 1/10 of their acquired property to anyone they please. They shall not be criticized if they give the rest of their property to their adopted son and establish a friendship with them according to the law. If a man's sons require guardians and the father, upon his death, leaves a will appointing guardians, those named by him, regardless of their number, shall be recognized as guardians if they are capable and willing to take care of the children, according to the provisions of the will. However, if the father dies without making a will or appointing guardians, then the next of kin, 2 from the father's side and 2 from the mother's side, as well as one of the deceased's friends, shall have the authority to be guardians. The guardians appointed by the law shall determine who will be the guardians when the orphans require them. The 15 eldest guardians appointed by the law shall have the complete responsibility and care of the orphans. They shall be divided into groups of 3 according to seniority, with one group serving for 1 year and then another group serving for the next year, until the cycle of 5 periods is complete. This arrangement shall continue as much as possible. If a man dies without making a will at all and leaves behind daughters who require guardians, they shall receive the protection provided by these laws. If a man dies unexpectedly and leaves daughters behind, let him forgive the legislator if, when arranging their marriages, the legislator only considers 2 out of 3 conditions, proximity of kin and the preservation of the lot. The legislator may omit the 3rd condition, which a father would naturally consider, as he would choose a son-in-law based on his character and disposition. The father shall forgive the legislator for disregarding this impossible consideration. The law regarding these matters, where feasible, shall be as follows. If a man dies without making a will and leaves behind daughters, his brother, who is the son of the same father or mother and has no lot, shall marry the daughter and receive the deceased man's lot. And if he does not have a brother, but only a nephew, they should marry in the same way if they are of a suitable age. And if there is no nephew, but only a niece, they should do the same, and so on in the fourth degree if there is only the testator's paternal uncle, or in the fifth degree, his paternal cousin, or in the sixth degree, the child of his paternal aunt. Kinship should always be calculated in this way. If a person leaves behind daughters, the relationship should proceed upwards through siblings and their children, with males taking precedence and then females in the same family. The judge should consider and determine the suitability or unsuitability of age for marriage. He should inspect the males naked and the women naked down to the navel. And if there is a lack of relatives in a family extending to the grandchildren of a brother, or to the grandchildren of a grandfather's children, the maiden may choose, with the consent of her guardians, any citizen who is willing and whom she desires, and he will be the heir of the deceased and the husband of his daughter. Circumstances vary, and there may sometimes be an even greater lack of relatives within the state. If any maiden has no living relatives in the city, and there is someone who has been sent out to a colony, and she wishes to make him the heir of her father's possessions, if he is indeed of her kin, he should proceed to take the inheritance according to the regulation of the law. But if he is not of her kin, and she has no relatives within the city, and he is chosen by the deceased's daughter and authorized to marry by the guardians, he should return home and take the inheritance of the deceased who died without a will. And if a man has no children, either male or female, and dies without making a will, the previous law should apply. A man and a woman should leave the family and share the abandoned house, and the inheritance should belong to them absolutely. The heiress in the first degree should be a sister, and in the second degree, a daughter of a brother, and in the third degree, a daughter of a sister, in the fourth degree, the sister of a father, and in the fifth degree, the daughter of a father's brother, and in the sixth degree, a father's sister. These individuals should live with their male relatives, according to the degree of relationship and right, as we previously enacted. Now we must not ignore the fact that such laws can be oppressive and that there may sometimes be a hardship in the lawgiver commanding the relative of the deceased to marry their relation. It may be thought that the lawgiver did not consider the numerous obstacles that may arise among people in the execution of such ordinances. There may be cases in which the parties refuse to obey and are willing to do anything rather than marry, especially when there is some physical or mental illness or defect among those who are commanded to marry or be married. Some may think that the legislator never thought of this, but they are mistaken. Therefore, let us make a common prelude on behalf of the lawgiver and his subjects, with the law asking the latter to forgive the legislator, as he, having to take care of the common good, cannot simultaneously order the various circumstances of individuals. The law asks the subjects to pardon them if they are sometimes unable to fulfill the act that the law, in its ignorance, imposes on them.
And how, stranger, can we act most fairly under these circumstances?
There must be arbitrators chosen to deal with such laws and their subjects.
What do you mean?
I mean to say that a situation may arise in which the nephew, having a wealthy father, will be unwilling to marry the daughter of his uncle. He will have a sense of pride and will want to aim higher. And there are cases in which the legislator will be imposing the greatest calamity on him, and he will be compelled to disobey the law if he is required, for example, to marry a wife who is insane or has some other terrible illness of the mind or body that makes life unbearable for the sufferer. Then let what we are saying about these cases be included in a law. If anyone finds fault with the established laws regarding wills, both in other matters and especially in relation to marriage, and asserts that the legislator, if he were alive and present, would not compel him to obey, that is to say, would not compel those who are required by our law to marry or be given in marriage to do so, and if some relative or guardian disputes this, the reply is that the legislator left 15 of the guardians of the law to be arbitrators and guardians of orphans, whether male or female. The disputants should have recourse to them and, with their help, resolve any such matters, accepting their decision as final. But if anyone thinks that too much power is given to the guardians of the law, let him bring his adversaries to the court of the select judges and have the disputed points determined there. And the one who loses the case shall receive censure and blame from the legislator, which, to a sensible person, is felt to be a penalty far more severe than a great loss of money. Thus, orphan children will have a second birth. After their first birth, we discuss their upbringing and education, and after their second birth, when they have lost their parents, we should take measures to make the misfortune of orphanhood as little sad for them as possible. Firstly, we declare that the guardians of the law are lawmakers and caretakers, not inferior to their biological fathers. They shall take responsibility for them on an annual basis as if they were their own relatives. We have provided appropriate guidance to both the guardians and the children's own caretakers regarding the upbringing of orphans. In our previous discussion, we mentioned that the souls of the deceased can take an interest in human affairs after death. There are many tales and traditions about this, which are lengthy but true. Considering their abundance and antiquity, we must believe them, as well as the lawmakers who affirm their truth. Otherwise, we would consider them complete fools. If these things are indeed true, then firstly, men should fear the gods above, who pay attention to the plight of orphans. Secondly, they should fear the souls of the departed, who naturally have a special concern for their own children and are friendly to those who honor them, but unfriendly to those who dishonor them. Men should also fear the souls of the living who are elderly and highly respected. In well-ordered and prosperous cities, their descendants cherish them, leading to a happy life. The elderly are observant and attentive to matters concerning them, and they favor those who fulfill their duties justly. They punish those who wrong orphans and the destitute, considering them the most important and sacred responsibilities. The guardian and magistrate should focus their attention on all these matters, if they possess any sense, and take care of the upbringing and education of orphans. They should seek every possible way to do good for them, as they are contributing to their own well-being and that of their children. Those who obey the principles preceding the law and do no harm to an orphan will never face the wrath of the lawmaker. However, those who disobey and harm someone who is deprived of their father or mother will face a penalty twice as severe as if they had harmed someone whose parents were alive. Regarding other legislation concerning guardians and their relationship with orphans, or concerning magistrates and their supervision of guardians, if we did not have examples of how the children of free people should be raised, based on the upbringing of their own children and the care of their property, or if we did not have just laws clearly stated about these matters, then it would be reasonable to create laws for them, considering them a distinct group. We could establish separate rules for the lives of orphans and non-orphans. However, as it stands, the situation of orphans among us is not different from those who have a father, although they are not usually treated with the same level of honor and attention. Therefore, when it comes to legislation about orphans, the law speaks with seriousness, using both persuasion and threats. A threat such as the following is entirely appropriate: the guardian of an orphan, regardless of their gender, and the overseer of this guardian among the guardians of the law, should love the unfortunate orphan as if they were their own child. They should manage their possessions with the same care and diligence as they would if they were their own, or even more so. Let everyone who has the responsibility of an orphan adhere to this law. However, anyone who acts contrary to the law in these matters may be fined by a magistrate. If the guardian is a magistrate themselves, the guardian may bring them before the court of select judges and, if convicted, punish them by imposing a fine twice the amount determined by the court. If a guardian appears negligent or dishonest to the orphan's relatives or any other citizen, they should bring them before the same court. If the guardian is convicted, they should pay 4 times the damages awarded, with half going to the orphan and half to the person who brought the conviction. If an orphan reaches the age of maturity and believes they have been mistreated by their guardians, they should be allowed to bring them to trial within 5 years of the end of the guardianship. If any of the guardians are convicted, the court will determine what they should pay or suffer. If a magistrate is found to have wronged an orphan through neglect and is convicted, the court will determine what they should suffer or pay to the orphan. If there is also dishonesty in addition to neglect, the magistrate should not only pay the fine but also be removed from their position as guardian of the law. The state should appoint a new guardian of the law for the city and the country in their place. Sometimes, greater differences arise between fathers and sons than there should be. This can be due to fathers who believe that the legislator should enact a law allowing them to lawfully disown their son by publicly proclaiming it through a herald. On the other hand, sons may think they should be allowed to accuse their fathers of incompetence when they are disabled by illness or old age. These things only happen when the nature of men is completely bad. When only half is bad, such as when the father is not bad, but the son is, or vice versa, the result of such hatred is not a great calamity. In another state, a son disowned by his father would not necessarily cease to be a citizen. However, in our state, which is governed by these laws, the disinherited must emigrate to another country. This is because our state cannot accommodate any additional households beyond the existing 50-40. Therefore, anyone who deserves to suffer such consequences must be renounced not only by their father, but by the entire family. The process for such cases should be regulated by the following law. If a father, in the troubled state of his mind, desires to expel a son whom he has begotten and raised, he must not hastily execute his intention. Instead, he should gather his own relatives, including cousins, as well as the son's relatives from the mother's side. In their presence, he should accuse his son, stating that he deserves to be dismissed from the family. The son should be given the opportunity to address them in a similar manner and demonstrate that he does not deserve to suffer such consequences. If the father persuades them and obtains the support of more than half of his relatives, excluding the father, mother, and the son himself, then the father will be allowed to disown his son. Otherwise, if the majority does not support the father's decision, he cannot proceed with disowning his son. If any other citizen is willing to adopt the disowned son, there should be no legal hindrance. This is because young people's characters often change throughout their lives. However, if no one is willing to adopt the son within a period of 10 years, the responsibility falls upon those who oversee the surplus population sent to colonies. They should ensure that the son is appropriately provided for in the colony. In cases where a person's mental state, whether due to illness, old age, temperament, or a combination of these factors, causes them to be more irrational than the rest of society, although this may only be noticeable to those who live with them, and they, as the owner of their property, become a detriment to the household, their son may hesitate to accuse them of insanity. In such cases, the law should stipulate that the son must first approach the eldest guardians of the law and inform them of his father's unfortunate condition. They should thoroughly investigate the matter and advise the son on whether to proceed with the accusation. If they recommend proceeding, they should act as both witnesses and advocates for the son. If the father is found to be mentally unfit, he will henceforth be incapable of making any decisions for himself and will be treated as a dependent in the household for the rest of his life. In cases where spouses have an unfortunate incompatibility of temper, 10 impartial guardians of the law and 10 women responsible for arranging marriages should intervene. If they can reconcile the couple, they should facilitate a formal reconciliation. However, if their emotions are too volatile, they should attempt to find other partners for them. Since these individuals are not likely to have gentle temperaments, they should be matched with partners who possess deeper and softer natures. Couples who have no children or only a few at the time of their separation should choose new partners with the intention of procreating children. On the other hand, couples who already have enough children should separate and remarry to have someone to grow old with and take care of each other in old age. If a woman dies, leaving behind children, whether male or female, the law will advise, rather than compel, the husband to raise the children without introducing a stepmother into the household. However, if the husband has no children, he will be compelled to remarry until he has fathered enough sons for his family and the state. If a man dies leaving behind enough children, the mother of his children should remain with them and raise them. However, if she is too young to live virtuously without a husband, her relatives should consult with the women responsible for arranging marriages. Together, they should determine the best course of action. If there is a lack of children, the choice of a new partner should be made with the intention of having children. According to the law, 2 children, one of each sex, will be considered sufficient. When there is a need to determine which parent a child belongs to, even though the child is acknowledged by both parents, the law states that if a female slave has intercourse with a male slave or a freeman or formerly enslaved person, The child will always belong to the master of the female slave. Similarly, if a free woman has intercourse with a male slave, the child will belong to the master of the slave. However, if a child is born to a slave by her master or to his mistress by a slave, and this is proven, the women responsible for arranging marriages will send away the offspring of the woman and its father to another country. The guardians of the law will also send away the offspring of the man and its mother. Neither God nor a person with understanding would ever advise anyone to neglect their parents. To discuss the honor and dishonor of parents, it is appropriate to begin with a prelude about the service of the gods. There are ancient customs regarding the gods that are universal and fall into two categories. Some gods are visible to us, and we honor them directly. For other gods, we honor their images by erecting statues and worshiping them. Although these statues are lifeless, we believe that the living gods appreciate and are grateful for this gesture. Now, if a man has an elderly father or mother, or their elderly parents, treasured up in his house, let him consider that no statue can be more powerful in granting his requests than they are, who are sitting at his hearth, if only he knows how to show true service to them.
And what do you mean by true service?
I will tell you, my friend, because such things are worth listening to.
Go on.
Oedipus, as tradition says, when dishonored by his sons, invoked curses on them which everyone declares to have been heard and approved by the gods, and Amyntar in his anger invoked curses on his son Phoenix, and Theseus upon Hippolytus, and countless others have also called down wrath upon their children, which makes it clear that the gods listen to the curses of parents, for the curses of parents are, as they should be, powerful against their children like no others. And shall we suppose that the prayers of a father or mother who is especially dishonored by his or her children are heard by the gods in accordance with nature, and that if a parent is honored by them, and in the joy of his heart earnestly asks the gods in his prayers to do them good, he is not equally heard, and that they do not fulfill his request? If not, they would be very unjust givers of good, and that we affirm to be contrary to their nature.
Certainly.
May we not think, as I was saying just now, that we can possess no image which is more honored by the gods than that of a father or grandfather or of an elderly mother? When a man honors them, the heart of the god rejoices, and he is ready to answer their prayers. And truly, the figure of an ancestor is a wonderful thing, far higher than that of an inanimate image. For the living, when they are honored by us, join in our prayers, and when they are dishonored, they utter curses against us, but lifeless objects do neither. And therefore, if a man makes proper use of his father and grandfather and other elderly relatives, he will have images which above all others will win him the favor of the gods.
Excellent.
Every man of any understanding fears and respects the prayers of parents, knowing well that many times and to many people they have been fulfilled. Now, with these things being ordered by nature, good men consider it a blessing from heaven if their parents live to old age and reach the utmost limit of human life, or if taken away before their time they are deeply mourned by them, but to bad men, parents are always a cause of fear. Therefore, let every man honor his own parents with every kind of lawful honor, in accordance with what has now been said. But if this prelude is meaningless to anyone, let the law follow, which may be rightly imposed in these terms: if anyone in this city is not sufficiently careful of his parents, and does not regard and fulfill their wishes more than those of his sons and other offspring or of himself, let the person who experiences this treatment either come himself, or send someone to inform the 3 eldest guardians of the law, and 3 of the women who have the care of marriages, and let them look into the matter and punish youthful wrongdoers with physical punishment and imprisonment if they are under 30 years of age, that is to say, if they are men, or if they are women, let them undergo the same punishment up to 40 years of age. But if, when they are even older, they continue to neglect their parents and harm them in any way, let them be brought before a court in which every single one of the eldest citizens shall be the judges, and if the offender is convicted, let the court determine what he ought to pay or suffer, and any penalty may be imposed on him which a man can pay or suffer. If the person who has been wronged is unable to inform the magistrates, let any freeman who hears of his case inform them, and if he does not, he shall be considered base, and shall be liable to have a lawsuit for damages brought against him by anyone who wishes. And if a slave informs, he shall receive freedom, and if he is the slave of the wrongdoer or the wronged party, he shall be set free by the magistrates, or if he belongs to any other citizen, the public shall pay a price on his behalf to the owner. And let the magistrates take care that no one wrongs him out of revenge, because he has given information. Cases in which one person harms another intentionally and with malice using poisons, and which prove fatal, have already been discussed, but about other cases in which a person intentionally and with malice harms another with food, or drinks, or ointments, nothing has yet been determined. For there are two kinds of poisons used among people, which cannot clearly be distinguished. There is the kind just now explicitly mentioned, which harms bodies by the use of other bodies according to a natural law. There is also another kind which persuades the more daring class that they can harm others through sorcery and incantations and magic knots, as they are called, and makes others believe that they above all people are harmed by the powers of the magician. Now it is not easy to know the nature of all these things, nor if a man does know, can he easily persuade others to believe him. And when men are disturbed in their minds at the sight of waxen images fixed either at their doors, or in a place where three ways meet, or on the graves of parents, there is no use in trying to persuade them that they should disregard all such things because they have no certain knowledge about them. But we must have a law in two parts, concerning poisoning, regardless of the method used in the attempt. We must urge and advise people not to resort to such practices, which frighten the masses as if they were children. This forces the legislator and judge to address the fears that the sorcerer arouses. First and foremost, they must explain that those who attempt to poison or enchant others do not utterly understand what they are doing, either in terms of the physical body, unless they have knowledge of medicine, or in terms of their enchantments, unless they happen to be prophets or diviners. The law regarding poisoning or witchcraft should be as follows. If a physician is convicted of using poison to cause non-fatal harm to a person, their servants, or any harm, fatal or not, to their livestock or bees, they shall be punished with death. If a private individual is convicted of the same, the court shall determine the appropriate punishment or compensation. However, if someone is found to be practicing magic using knots, enchantments, incantations, or similar methods, and they are a prophet or diviner, they shall be put to death. If they are not a prophet and are convicted of witchcraft, the court shall determine the appropriate punishment or compensation, as in the previous case. When a person causes harm to another through theft or violence, they should pay greater damages for greater harm and lesser damages for lesser harm. In all cases, the compensation should be sufficient to cover the loss. In addition to compensating for the wrong, the offender should also face additional penalties to serve as punishment for their offense. If the wrong was committed due to the influence of another person's foolishness, youthfulness, or similar factors, the penalty should be lighter. However, if the offender acted out of their own foolishness, driven by pleasure, pain, cowardice, lust, envy, or unrelenting anger, they should face a harsher punishment. The purpose of this punishment is not to undo the wrong that was done, for that is impossible, but rather to instill a deep hatred of injustice in the offender and those who witness their correction, in the hopes of reducing future wrongdoing. In order to achieve this, the law should aim, like a skilled archer, to impose the appropriate and deserved punishment in all cases. The judge should work alongside the legislator to determine the specific punishment or compensation when the law allows for such discretion. The legislator, on the other hand, should provide a general framework outlining the cases to which the law should be applied, much like a painter sketching the outline of a painting. This is what we must do, Megillus and Cleinias, in the best and fairest way possible. We must establish the punishments for all actions involving theft and violence and create laws that align with the desires of the gods and their divine offspring. If a person is deemed to be mentally ill, they should not be allowed to roam freely in the city. Instead, their relatives should do everything in their power to keep them at home. If they fail to do so, they should be subject to a penalty. The highest class of relative should pay a penalty of 100 drachmas, whether the person they neglect is a slave or a freeman. The second class should pay 4/5 of a mina, the third class 3/5, and the fourth class 2/5. There are many forms of madness, some caused by disease, as we have already discussed, and others stemming from a wicked and passionate temperament exacerbated by poor education. Individuals from this latter category of madmen often escalate a minor quarrel into a storm of verbal abuse against each other. Such behavior should not be tolerated in a well-ordered state. Therefore, the law regarding verbal abuse should be as follows: no one shall speak ill of another person. When engaging in a dispute, a person should teach and learn from their opponent and the company present, but they should refrain from engaging in verbal abuse. It is from the curses and insults that people hurl at each other, the habit of slandering and using foul language, that the greatest enmities and hatreds arise. The speaker gratifies their anger, an ungracious aspect of their nature. By nurturing their wrath through entertaining evil thoughts and exacerbating the uncivilized part of their soul that was once tamed by education, they live in a state of savagery and sullenness, paying a bitter price for their anger. In such cases, everyone resorts to saying something ridiculous about their opponent. Anyone who habitually mocks others lacks virtue and seriousness, or at least lacks a significant portion of these qualities. Therefore, no one should utter any taunting words at a temple, during public sacrifices, at games, in the agora, in a court of justice, or in any public assembly. The magistrate presiding over these occasions should punish offenders, and they shall be considered blameless for doing so. If the magistrate fails to act, they cannot claim to possess virtue, for they are disregarding the laws and failing to fulfill the legislator's commands. If anyone engages in such reviling in any other place, whether they initiated the quarrel or are retaliating, any elder present should support the law and restrain those consumed by passion, which is another great evil. If the elder fails to do so, they should be liable to pay the prescribed penalty. And we now say that someone who engages in reproaching others cannot do so without attempting to ridicule them. When this is done in a moment of anger, we consider it a matter of reproach against that person. However, do we allow comic writers into our state who are fond of making people ridiculous, if they attempt to do so in a good-natured manner and without anger towards our citizens? Or do we distinguish between jest and seriousness, allowing someone to use ridicule in jest and without anger towards anything or anyone, if they do not have a specific purpose in mind? We prohibit seriousness, which is firmly established. But we still need to determine who is allowed or not allowed, according to the law, to use innocent humor. A comic poet or writer of iambic or satirical lyric verse shall not be permitted to ridicule any of the citizens either through words or images, whether in anger or without anger. And if anyone disobeys, the judges shall either immediately expel them from the country or they shall pay a fine of 3 minae, which will be dedicated to the god who presides over contests. Only those who have received permission shall be allowed to write verses against each other, but they must do so without anger and in jest. They shall not be allowed to do so in anger or with serious intent, as we have previously stated. The decision regarding this matter shall be left to the superintendent of general education for the youth, and whatever he permits, the writer shall be allowed to produce. And whatever he rejects, the poet himself shall not exhibit or teach to anyone else, whether slave or freeman, under the penalty of dishonor and being considered disobedient to the laws. Now, it is not the person who is hungry or experiencing physical pain who should be pitied, but rather the person who is temperate or possesses some other virtue or part of a virtue, and at the same time suffers from misfortune. It would be extraordinary if such a person, whether slave or freeman, were completely abandoned and fell into extreme poverty in any well-organized city or government. Therefore, the legislator may safely enact a law applicable to such cases with the following terms: there shall be no beggars in our state. And if anyone begs, seeking to make a living through futile prayers, let the wardens of the marketplace expel them from the marketplace, the wardens of the city expel them from the city, and the wardens of the countryside send them out of any other parts of the land across the border, in order to clear the land of this kind of person. If a slave, whether male or female, damages something that does not belong to them due to inexperience or improper practice, and the person who suffers the damage is not partially to blame, the slave's master shall either fully compensate for the damage or surrender the slave who caused the harm. However, if the master argues that the accusation has arisen through collusion between the injured party and the one who caused the harm, with the intention of obtaining the slave, then the master should sue the person who claims to have been injured for misconduct. If the master wins the case, he shall receive double the value determined by the court as the price of the slave. If he loses the case, he shall make amends for the injury and give up the slave. Similarly, if a domesticated animal such as a beast of burden, horse, dog, or any other animal damages a neighbor's property, the owner shall also pay for the damage. If someone refuses to be a witness, the person who needs them as a witness shall summon them, and the summoned person shall attend the trial. If they know the information and are willing to testify, they should do so. But if they claim not to know, they should swear by the three deities Zeus, Apollo, and Themis that they do not know, and have no further involvement in the case. If someone is summoned to give witness and does not respond to the summoner, they shall be held responsible for any harm that occurs as a result, according to the law. And if a person calls upon someone who is acting as a judge to be a witness, they may give their testimony, but they shall not vote in the case afterwards. A free woman who is over 40 years old may give her testimony and argue her case, and she may bring a legal action if she does not have a husband. However, if her husband is alive, she shall only be allowed to bear witness. A slave, whether male or female, and a child shall be allowed to give evidence and argue their case, but only in cases of murder. They must provide sufficient sureties that they will remain until the trial in case they are charged with false witness. Either party in a case may accuse witnesses of perjury, claiming that they have given false evidence either in whole or in part. However, this accusation must be made before the final decision of the case. The magistrates shall keep records of accusations of false witness, sealed by both parties, and present them on the day of the trial for false witness. If a person is convicted of false witness twice, they shall not be required to testify, and if convicted 3 times, they shall not be allowed to testify. And if they dare to testify after being convicted 3 times, anyone who wishes may inform the magistrates, who shall then hand them over to the court. If they are convicted, they shall be punished with death. And in any case where it is rightly determined that the evidence is false, yet it has led to the victory of the winning party in the lawsuit, and more than half of the witnesses are condemned, the decision that was obtained through these means shall be revoked. There shall be a discussion and a decision as to whether the lawsuit was decided based on that false evidence or not. Whichever way the decision is given, the previous lawsuit shall be determined accordingly. There are many noble things in human life, but most of them are accompanied by evils that are destined to corrupt and ruin them. Isn't justice noble, as it has civilized humanity? How then can the advocate of justice be anything but noble? And yet, this profession, which is presented to us under the honorable name of art, has acquired a bad reputation. Firstly, we are told that through clever arguments and the assistance of an advocate, the law allows a person to win a particular case, whether it is just or unjust. Both the art itself and the power of speech that it imparts are available to those willing to pay for them. In our state, this so-called art, whether it is truly an art or simply an experience and practice devoid of any art, should never come into existence if possible. If it does exist among us, it should heed the request of the legislator and go away to another land, and not speak against justice. If the offenders obey, we say no more. But for those who disobey, the voice of the law is as follows: if anyone believes that they can pervert the power of justice in the minds of the judges and engage in litigation or advocacy at an inappropriate time, let anyone who wishes to do so indict them for misconduct and dishonest advocacy. Let them be judged in the court of select judges. If they are convicted, let the court determine whether their actions stem from a love of money or from contentiousness. If it is determined that they act out of contentiousness, the court shall impose a period during which they are not allowed to initiate or plead a case. If it is determined that they act out of a love of money, and if they are a foreigner, they shall leave the country and never return under the penalty of death. If they are a citizen, they shall be put to death because they are a lover of money, regardless of how they acquired it. Similarly, if they are judged to have acted out of contentiousness more than once, they shall be put to death.